may find that, somewhere that has a lot of commercial strip mall type properties that backs right up to residential, if that's your primary commercial district, then almost any buffer zone between residential and that property is going to result in that property being disqualified, which is fine if that's what the council wants. But it's a matter of planning and it's not really a legal question so much really as it is a planning question of how do you want this to lay out and where do you want these facilities to be located.
I'm not sure if I stated this at the beginning, but using Westland as an example, I think the council and the previous administration took the approach to opt out, allow other communities to lead with their chin, and then learn from those communities that went first. So the thought being, if we stay close to what an existing community has done, and they've already fought the legal battle, then the hope is that they set the precedent and that we would not have to relitigate that. So maybe this is a good time to where does the city of Westland stand on appeals or initial cases? What's been their victories? What have been their failures? That's the next slide.
Yeah, I actually moved to that slide while somebody was talking, but so there's been significant litigation. Many communities, I won't say all or most, but many communities that have implemented structures that involve choosing more or less winners and losers. Those communities are more likely to be sued, obviously. I think if the strategy is maximum risk avoidance, I think the best chance of not getting sued is by staying out of it completely and not really doing any recreational marijuana. That's the slant of the council. Then that would sort of be the way to accomplish that. Also, I would suggest not just looking to places that have been challenged and won, but also to places that implemented processes that didn't get challenged in court at all. Would be another thing to look at. I don't know if there's a ton of them out there, but I think there's some. I do think there's some. Where Westland stands, and I knows I won't comment on pending litigation, but of public record, there were numerous lawsuits that got consolidated. We did win those on summary disposition at the trial court level. They are all currently awaiting briefing and things like that on appeal. I fully expect that no matter who wins the appeal, the other side will appeal again, and it'll maybe end up at the Supreme Court as a matter of first impression. So that's going to be an ongoing thing for the foreseeable future. Not necessarily just for Westland, but for any community that's been sued.
The chair, if I might. Brandon has been successful in one litigation suit in the wake of the Court of Appeals decision, but Westland's involved in more than just one lawsuit.
Well, there were numerous lawsuits that got consolidated, so it's one case, so to speak, but has probably 8 or 9 plaintiffs in it, and then some of the winners, so to speak, intervened also. So it's kind of a complex bit of litigation, actually. But yeah, there's 8 or 9 plaintiffs, I believe.
Thanks a lot. Any questions?
Council.
So precedent, even the ones that win, doesn't stop people from filing a lawsuit that we would still have to defend, right?
That's correct.
Could be all the way up to. So it's good that you win, but even when you win, you lose because you have to pay all the legal fees.
That's right. And I would, I'll let your counsel comment on insurance coverage and things like that you need to be aware of, things that could potentially not be covered. For example, if your typical policy would exclude coverage for things like injunctive relief or declaratory relief. So there's different things like that to take into consideration as well as you look at what might get litigated.
Councilman?
What would you say is the predominant number of lawsuits against your city right now? What would they be for? What would be the reasoning? What are some of the top priority reasons why you're being sued?
For marijuana specifically?
Yeah.
Well, very common is like a due process type challenge. That your procedure was unfair. Open Meetings Act type challenges we've seen. Some of these are multi-count complaints in terms of 10 plus counts. So there's really no one thing, I wouldn't say, but I think some common challenges from sort of around the state involve, specific selection criteria potentially being invalid, or at least allegedly by the plaintiff's crowd being invalid under the Regulation and Taxation of Marijuana Act.
The biggest thing that kind of throws me, doing my job, what I did for 38 years as a police officer. Now we have another situation where we're opening up marijuana stores and all that good stuff, right? But yet I got liquor stores that sit on every corner, everywhere in this state. And what makes the difference between the liquor store and a marijuana store? But yet, we have all these problems with the marijuana setup, but yet we have all the liquor stores already out there. And liquor stores have proven themselves, okay, they're there. How many traffic accidents that we get caused by liquor? And some of the issues that I've had with this all along through the years, I did my job because that's just the way it was. Agree with it back then? Actually, I didn't. Why? Because I enforced it. Now I think the biggest point comes down to now is you got party stores that sell liquor. Now we're going to have basically a party store selling marijuana. And I'm just wondering, why would there be so much litigation when the party stores have pretty much proven that through the years? How much litigation do you hear about party stores getting licenses from the state? They give them, you see what I'm saying?
So I don't think you hear too much about liquor store litigation now because it's already been litigated. I think there's probably a significant number of cases out there. I've certainly seen and researched some of those cases in the course of researching marijuana litigation, but there's definitely been a fair bit of litigation concerning liquor licenses, and to some extent it continues.
But you would think by now, between the litigation of liquor stores, why would there be so much to it just marijuana? Okay, so I sell you a glass of whiskey, or I sell you a little joint. What's the difference?
So I think it kind of stems back in a way to the marijuana regulatory scheme at the state level is somewhat unique in that it allows the city to impose a hard cap on the number of licenses. Okay, that's sort of unique in the land use and in the zoning world. You don't typically see a hard cap on the number of a particular type of business that can be located in a municipality. You may have land use regulations, you may have zoning ordinances that restrict certain uses in certain areas and things like that, but it's not something that I don't think at least is common in the municipal arena.
Okay. Councilman Johnson?
So going along with Mr. Remick's comment, this is new, we're able to put a cap on it. I think every store in the city sells beer, and then you got liquor stores. So I don't see the difference. This is new, so we're going to have growing pains. Once we get through that, 10 years down the road, you're not even going to know about it. My opinion.
And then just one comment, when I first started on the council, the liquor licenses were restricted within the city of Taylor, and the law changed that allowed liquor licenses to move within the county. And so, bar licenses, we saw a lot of transfer, but historically, there was limits within the code, and then once they opened it up in Wayne County, there really isn't any restriction. Sorry.
To that point, is liquor and beer separate? Because you can buy beer in any store here in Taylor.
Beer and wine and liquor, so.
Yeah.
Separate, okay.
But,
You can get just as drunk on beer and wine as you can on liquor.
but